In fact, y'all were specifically ordered not to get involved, correct?
That is correct.
And you followed those orders, did you not?
Yes, sir.
So when Brian Weiss appeared on July 7th to start presenting the Paxton case, you had no participation in that at all, did you?
That is correct.
Did you even know Brian Weiss?
I've met Brian before, yes.
Okay, but nothing having to do with the Paxton case, correct?
That is correct.
There's a man here, Stacy McNeil. Can I get you to stand up? Do you recognize the gentleman standing up back there, next to Ranger McNeil?
I think he showed up the day Judge Tucker introduced two of you to that grand jury, and I think that's the first time I've ever seen him.
Okay. Well, let's move back just a bit. You can, let's take you back just a little bit in time. You were there the day Judge Tucker brought us before a grand jury, correct?
Yes.
And that's not the grand jury that ultimately heard the case, correct?
That is correct.
You recall that the reason we were brought in there is because the grand jurors at that grand jury, Judge Tucker's, had taken possession of a file from the Travis County District Attorney's Office, and that we showed up to take possession from them.
It's my understanding, I didn't personally witness that.
But that was your understanding, correct?
Yes, sir.
It was further your understanding that we never presented anything to that grand jury.
That is my understanding.
And
Yes.
the term of that grand jury ended in June 2015, prior to the time we ever presented anything, correct?
That is correct.
So, on the morning of July 7, 2015, when Mr. Weiss and Ranger McNeil showed up at the grand jury room, the grand jurors didn't know who they wouldn't have known who they were, correct?
I would assume they would not know who they were.
Well, you certainly didn't introduce Mr. Weiss to the grand jury, did you?
I did not.
You didn't tell the grand jury that you're going to be hearing from the special prosecutor today, correct?
I might have mentioned it at some point that they were going to.
Okay. I have, or you did?
I think I did. I think I told them because Judge Olner had told me that he was going to be coming around 11, and I told them I was going to try to work my docket until that point, and then the special prosecutor coming.
And what Judge Olner told you is that he was going to come before the grand jury to explain that they would be hearing from the special prosecutor and to actually introduce the special prosecutor who would be presenting the case, correct?
I didn't really have a detailed conversation with Judge Olner about what he was going to say, but that was my understanding.
And there wouldn't be anything improper about that if Judge Olner had done that, correct?
I don't think so.
Specifically, the law says that a person may not enter the grand jury room while the grand jury is deliberating, correct?
That is correct.
And Judge Olner did not enter that grand jury during the time the grand jury was deliberating, did he?
Not to my knowledge, but I wasn't there.
Well, if he did, you certainly wouldn't be the person to ask, correct?
That is correct.
And nobody told you that that happened, correct?
That is correct.
Furthermore, Judge Olner would not have been, as far as you know, was not present at the time when any evidence was being presented to the grand jury, correct?
I don't know, so I wasn't there.
Do you have any reason to believe that he was?
Objection has to answer.
That was not asked or answered, Your Honor.
I'm going to let this be, move on, so let's go.
Any reason to believe that that happened?
I didn't see it. I didn't see any of the testimony, any of the presentation. So.
Okay. So what you do know essentially is that Judge Olner showed up to introduce Mr. Weiss and then came back later to receive the truth, correct?
Correct.
All right. Now you know from the Code of Criminal Procedure that while a clerk can receive an indictment from a grand jury, so can the judge who presides over that grand jury, correct?
Yes.
And that happens sometimes, doesn't it?
It's not our normal course, but the code does allow for it.
Okay. And that could be because it's an indictment that's going to be sealed, or perhaps the grand jury chooses for whatever reason to present it to a judge as opposed to a clerk, correct?
That could be happening without the sealed indictment.
In the 20-something years you've been as an assistant district attorney, you haven't had a sealed indictment case here?
Yes. Not me personally. There's other divisions in our office that present cases that might have.
Okay. You also, in the 20 years you've been here, never saw a defendant summons to court as opposed to being arrested, correct?
I can't think of a time that's good.
If so, it's certainly uncommon in Collin County for that to happen, right?
Yes.
So even though there may be a provision in law, that's something that here is just not common.
Yes.
You talked about reporting in the grand jury room. There's also a common practice here, a local rule, that unless a civilian witness is testifying or a defendant is testifying before the grand jury, it typically is not reported or taken down by a court reporter, correct?
For our purpose, it's not even civilians are commonly reported, only defendants.
Certainly, if you have a law enforcement witness, you don't bring in a court reporter to report that, correct?
We do not.
The law does not require it, correct?
That is correct.
Not only is not the law not require it, but it's the local rule here that just doesn't happen, correct?
I'm not sure if it's a local rule or not, but I have not seen anyone record law enforcement's testimony.
In 20 years that you've been here?
Correct.
You also know from 20 plus years as a prosecutor that on those occasions when indictments remain sealed, it's because there's a concern that the defendant will flee or resist law enforcement, correct?
That's my understanding of the reasoning, sir.
For instance, officers might be able to go out and effectuate an arrest without a defendant being ready and perhaps shooting at them or trying to run away, correct?
That's my understanding, sir.
Okay, and in those instances where there is concern about that, the indictments can remain sealed, correct?
I believe so. I've never done it, though.
Okay, because typically, if there's an indictment for somebody and they're not in custody or on bond, they're just arrested, correct?
That the indictment triggers the warrant, that is correct.
Okay. But if, for whatever reason, you as a prosecutor don't want to see a defendant arrested at his place of business or at his home, there are other arrangements you can make to ensure that that does not happen, correct?
Yes, sir.
It's just unusual that you would extend that courtesy to a criminal defendant, correct?
Yes, sir.
I'll pass it over.
Mr. Hill, read the record.
Yes, sir. Directing attention back to June of this year, before the impanelment of the grand jury, which happened on the 12th of June, you knew that the grand jury was considering, you knew that a grand jury would be considering the fate of Mr. Paxton, didn't you?
I knew that an investigation had begun. I didn't know what stage or at what point it would get presented to grand jury.
And you also, and you knew that in part because of the wide publicity that the matter has generated, don't you?
In part.
Right, and you heard it on television and you read it in the newspapers, isn't that a fact?
A little bit.
Yeah, and it would be reasonable to assume, would it not, that the prospective grand jurors, when they arrived on June 12th, would have also heard that too and know that there would be a matter involving General Paxton at some point, involving a grand jury. Isn't that right?
I wouldn't assume that, no.
Well, it did get a fair amount of publicity here even before the impanelment of the grand jury, didn't it?
I believe it did.
Okay. And when the Olner grand jury met, when the impanelment process occurred, there was a new procedure that was in the selection of the grand jurors. Isn't that a fact?
I'm not sure I understand the question.
Well, there was a call for volunteers. Is that right?
It was not new to that selection, no, sir.
Well, Mr. Paxton said in the proceeding that you were there that he was going to try something new, and that involved asking for volunteers that wanted to serve on the grand jury. Isn't that right?
I don't remember his wording, but there had been a couple of judges that had done that prior to Judge Olmer selecting this grand jury.
And that would have been in close proximity, like maybe in the grand jury, that grand juries since January 1 of 2015. Isn't that a fact?
There may have been some in 2014 as well, I'm not sure.
But it was a new procedure that wasn't normally done. Isn't that right?
It had become the norm for the judges that did driver's license selection.
Okay. And when Mr. Schaefer asked you about, Mr. Olner's relationships with any of the prospective grand jurors, you have no idea if Judge Olner knew any of these people prior to their selection, do you?
I do not.
Okay. And Mr. Schaefer also asked you about the grand jury involved with Judge Tucker, which predates Judge Olner's grand jury. You recall that?
Yes, sir.
Right. And so if there was any grand jury work that was done, you said that you weren't aware of any. Is that correct?
That is correct.
Okay. And if the Rangers had served grand jury subpoenas in March of 2015, where would they have gotten those grand jury subpoenas?
If they've gotten them served,
If they issued grand jury subpoenas, where would they have gotten those subpoenas?
it was signed by a foreman of the grand jury, and it would have been from the grand jury.
Okay, and so is there any way in your experience that an agent, or in this case, DPS agents, could get records in an investigation without a grand jury subpoena if they're working under a grand jury?
I'm not sure I fully understand your question. Law enforcement oftentimes will use the grand jury to subpoena evidence prior to them presenting the case to our office and prior to us presenting that case to grand jury. It is when it's still in the investigative stages and they're trying to obtain information.
Right, and where do they get those grand jury subpoenas then, during that investigation?
They present them, well, if it's not a special prosecution case, they present them to us, the grand jury prosecutors. We review them. We then present them to the foreman. If the foreman signs off on it, it is then taken to the judge of that grand jury. If the judge signs off on it, it is then sent back to law enforcement that requested it, as well as the target that is.
And do you have any knowledge how it works with the special prosecutors then?
I do not.
And so if grand jury subpoenas were issued in April of 2015 under Judge Tucker's watch, then it would be for Judge Tucker's grand jury, isn't that right?
Not necessarily. They can participate in an investigation without being asked at the time to determine whether there's sufficient evidence for an indictment. So I guess not.
I understand that. I mean, during the investigative process, if there were grand jury subpoenas that were issued in April before Judge Olner's grand jury, then that would have been issued under Judge Tucker's watch.
That is correct.
Okay.
That is correct.
And when the grand jury meets, they're not always deliberating. Deliberating is a term of art that means that they're deliberating to determine if there's probable cause to indict. Isn't that right?
That's correct.
Okay, so when they're not actually holding a deliberation, they're still in proceedings. Isn't that right?
Yes, sir.
Okay, and the proceedings are just when the grand jury is meeting and when they're discussing and when they're analyzing, when they're asking questions, when they're hearing witnesses. Those are all proceedings. Is that right?
Yes, sir.
Okay, and Mr. Schaefer had also asked you about judges being allowed to get the true bill. Do you recall that? That they can retain a true bill as opposed to the district clerk?
Yes, sir.
Okay, and that's not normally done in this district, is it? It's the district clerk.
Yes, sir.
Yeah, and even if the judge were to get the true bill, the judge would have to give it to the district court to process. Isn't that right?
Yes, sir.
Okay, and because the law states also that a capias should issue upon the true bill. Isn't that right?
If they have not already been arrested, yes, sir.
Okay, and so it would be highly unusual if a judge were to hold on to a indictment for a 3-week period and not give it to the district court for processing. Isn't that right?
That would be unusual or different than the normal case.
You've never seen that before, have you?
No, not that I can think of.
Okay, and when an indictment is returned, it is put into the rotation, is that right?
For the most part, yes, there are some exceptions to that rule.
Okay, and what's the exception?
The defendant already has a pending case in court. He gets a new case. That case will get assigned to the court. He's already has pending cases in capital murders are on a rotating basis. They go on, so the 199 just got capital murder, the 219 will get the next one. They're specifically assigned so that one court doesn't get too many of those. If there's co-defendants, they're kept together. So if one co-defendant gets put in court, they will override the system to make sure all co-defendants get put in that same court.
Okay, and normally, how long is it between the true bill and the assignment of the judge?
Well, when the clerk comes to get the indictments and takes them upstairs, that's what he's doing, is he's entering them all into the computer and assigning cross numbers. If we finish in the early afternoon, it sometimes takes the following morning to get all the cross numbers back.
And typically, it takes how many potential judges could a matter be assigned to?
There's the 199, the 219, the 296, 366, the 388, the 407.
Okay, so in other words, you can go to one of any 7 judges, is that correct?
Yes, sir.
And are you aware if Mr. Weiss did a PowerPoint before the grand jury on July 7th?
I helped him set it up. I don't know if he presented it or not.
Okay, and when you helped him set it up, exactly what did you do in helping him set up the PowerPoint?
Just turned on the overhead projector and then showed him how to hook in his laptop into our system so that it would project.
So, grand jury matters are secret, are they not?
Yes, sir.
Okay, and that means, does that apply to the grand jurors, the secrecy?
Yes, sir.
And is that found in the Code of Criminal Procedure?
Yes, sir.
And does the secrecy laws apply to any bailiff that might be in the grand jury room?
Yes, sir.
And does the secrecy law apply to any stenographer that might be in the grand jury room?
Yes, sir.
And does the secrecy laws apply to you as the assistant district attorney?
In a limited regard, I can talk to other prosecutors and law enforcement. It's a little bit different for a prosecutor than it is for everyone else in the grand jury room.
Can you talk to the press?
No.
Okay. And when, and it's your understanding that the special prosecutors step in the shoes of the district attorney in this matter, is that right?
Yes, sir.
So the same secrecy laws would apply to them, would it not?
Yes, sir.
Okay. And the 416th grand jury that got this matter in June of 2015, that would not be their normal rotation for that court to have received a grand jury at this time. Is that correct?
I'm sorry, I don't quite understand.
Yeah, the grand juries are given to the judges on a rotating basis. Is that correct?
Yes, sir.
And it's my understanding that Judge Oldner had a grand jury the prior year, 2014, or thereabouts. You remember that?
I don't remember exactly when his last grand jury was.
Do you know if Judge Oldner took this grand jury out of turn?
He did, yes, sir.
Okay. And it would normally have been Judge Becker's grand jury, is that it?
That is correct.
Okay. Pass, Your Honor.
Mr. Sheck? The defense lawyer was just asking you about the issuance of a capias after a true bill is returned. I want to ask you some questions about that. The way it normally works is once the true bill's returned and the clerk issues the capias, the defendant's arrested if he's not already on bond or in jail, correct?
Yes, sir.
Now, have you seen situations where the defense lawyer specifically asked that his client not be arrested and be allowed to turn himself in at a later date?
That usually doesn't happen with us, but I do know that attorneys do ask if they can turn their clients in as opposed to being arrested. Yes, sir.
But once that capias and warrant have issued, there's nothing you can do to stop the procedure, correct?
That is correct.
Because once that warrant hits the system, any and every law enforcement officer in the state of Texas, if they come across that defendant, has the duty to arrest him, correct?
That's correct.
Irrespective of any deal that you and the defense lawyer may have, he's going to get arrested, correct?
Yes, sir.
All right. So, for instance, if the defense lawyer and the prosecution are in agreement, the judge has the right to hold off on having that capias issued, correct?
He has that ability, yes, sir.
Okay. So if that's the case, and in this case, Joe Kendall requested that I specifically not have Mr. Paxton arrested, and I agreed to it, it wouldn't be improper for the judge to hold off on having that capias issued until the agreed upon time, correct?
It would be unusual, but not, but okay.
And who benefits from it? The defendant, correct?
Yes, sir.
So let's talk about the way the grand jury was chosen. Mr. Hilder just asked you questions about whether it was unusual to ask for volunteers. You'd agree with me that at least 4 of the judges here do that now with the driver's license system, correct?
Yes, yes.
And the volunteer request is made after a time when those potential grand jurors have already been qualified, correct?
Yes, sir.
So the act of volunteering is not a qualification.
Yes, sir.
There are qualifications set out in the Code of Criminal Procedure, right?
Yes.
So when the judge, in this case Judge Older, goes before the 40 panel members that were there?
It's a lot larger than that, of 100, I believe.
Okay. Are those 100 already pre-qualified by the time they appear that day?
No, he qualifies in that.
All right. So he qualifies them, and that large number shrinks to a smaller number, correct?
Yes, sir.
And that's the qualified panel that he then selects from, correct?
Yes, sir.
So in this case, after that culling down had taken place and he had that qualified panel, the next thing he did is ask, is there anybody that wants to be on the grand jury, correct?
He tells them what the reasons to be excused are, and then rather than say who cannot, basically looks the question and says who can.
You know, why is that?
It makes the process a lot quicker. There's a lot fewer people that say I can and I'm willing as opposed to I don't want to, and here's my reason why.
Okay. Because even though they may be qualified, there are excuses that grand jurors or jurors can give that would excuse them from serving, correct?
Absolutely.
And in this county, grand jurors serve for 6 months at a time.
They do.
They're here 1 day a week.
Yes,
correct?
sir.
And that day could go from 9 in the morning until evening, or it could be till lunchtime, correct?
It is a big commitment, yes, sir.
All right. And it's not uncommon for grand juries to be here late into the afternoon.
It does happen that they are here in the afternoon, yes, sir.
In this case, Judge Older's grand jury meets every Tuesday, correct?
That is correct.
Judge Roach's grand jury, which is also in session now, meets every Thursday, correct?
That is correct.
So when the grand jury was chosen and the judge asked for volunteers, it was just a way to give grand jurors with excuses the ability to opt in, correct?
Absolutely.
But they were already qualified, were they not?
They will qualify.
The judge would have had the same right to stand before that grand jury and just close his eyes and pick 12 people at random if he had chosen to do that, correct?
Yes, sir.
Is there anything improper about the way he selected that grand jury, as far as you know?
I don't think so, no, sir.
Just 1 or 2 more questions, but Mr. Hilder was talking about what the term deliberate is. It is true, it is not, that Judge Older was only before that grand jury, as far as you know, prior to the time any evidence was presented and after the time the true bill had been returned, correct?
Objection. It's not been her testimony. I don't think she has any basis. I think it's asked and answered. She already says she doesn't know. She walked out of the grand jury room.
I'll suspend asked and answered.
first time that you saw Judge Older go into the grand jury room, Mr. Weiss had not yet been before the grand jury.
That's correct.
The next time you're aware of Judge Older going into the grand jury room was after his presence was summoned by the grand jurors to return to Kentucky. Right.
I know that he was down there to collect, or what I assume was to collect the indictment afterward. And I didn't see what happened individually.
And you're certainly not aware of any other instances that day when Judge Older went before the grand jury, right?
I did not see any other instances.
I'll ask you.
Just briefly, Judge. Mr. Schaefer had asked you about the issue of grand jurors being volunteers. There's what's called a motive test that's found in the Code of Criminal Procedure that is the test to qualify the grand jurors. There's approximately 4 questions, isn't that right?
Yes, sir.
Okay, and those 4 questions were asked of each of the prospective grand jurors after the asked by Judge Olner for volunteers, isn't that right?
Yes, sir. They were asked the qualifying questions before, but each one was asked after when they volunteered to ask the motive test questions.
Okay, and that's because the Code of Criminal Procedure says that each person shall individually have to answer the questions to be qualified, isn't that right?
They're qualified if they meet all the qualifications, and those were done in the beginning, and then they are additionally asked those 4 questions individually.
Well, those 4 questions weren't asked in the beginning of each individual grand jurors, now were they?
No, they were not.
Okay. And the ask for volunteers occurred before the individual prospective grand jurors were asked the 4 questions as called for in the Code of Criminal Procedures, isn't that right?
I believe so, but I know the qualifications were done, and people that weren't qualified were excused prior to that part.
Those were general questions, were they not?
Yes, sir.
Okay, they weren't the 4 statutory questions, were they?
I would have to have the statute in front of me. They were asked the qualifications initially, and then individually they were asked what you're calling the motive test, the 4 questions about are you a citizen, community united,
And that was after the individuals had volunteered, isn't that correct?
I believe so, yes, sir.
Okay. Pass again, Judge.
No questions, Your Honor.
May this witness be excused?
Yes, Judge.
Thank you. In dealing with any of the motions regarding grand jury, does both sides ask me to take judicial notice of court's exhibits 1 through 4 that were previously tendered the testimony or the paneling of the various grand juries that we had talked about previously?
Yes, Judge, and I think just for housekeeping matters, all of the exhibits that we have submitted with the various motions, if the judge would take judicial notice of them and admit them as well.
Same, ask for the same thing.
We would, Your Honor.
Okay, all right. Do you have any other testimony in regard to this motion, petition to disclose grand jury proceeding? Or actually, I'm sorry, the motion regarding the grand jury?
Yeah, that's all the live testimony that we have, Judge.
Do you wish to have any additional argument as to that motion?
Yes, sir, we do. If we may have a moment just to
Yes, sir.
set up
Take a
a
moment.
PowerPoint.
Do you have any problems with me? You might be no on your bench.
Okay, somebody help me. Okay.
I don't think it's going to be more like this. Why don't you have it when that's fine.
Mr. Hilder, if it's easier on you to make arguments and remain seated, you may do so.
Thank you, Judge.
Okay.
Judge, in conjunction with the live witness, we'd also like to make this presentation as a petition to disclose the grand jury proceedings. We'd like to, for the court to note that there were 3 presentations before the grand jury, which involves 5 indictments. On July 7th, which was the first indictment, we'll call indictment number 1, which involved the investment advisor representative without being registered indictment. Then there was the indictments, what we'll call 2 and 3, the securities fraud indictment that was July 28, 2015. And then on August 18, 2015, indictments 2 and 3 were dismissed, and if you would, indictments 4 and 5 were then true billed by the same grand jury as such, and that's what we're dealing with here. So indictments 4 and 5 are the ones that we're dealing with that reflect what was actually indicted on July 28th. So we believe that we're entitled to any grand jury transcript, any matters that went before the grand jury, and that the Code of Criminal Procedure allows us, and under 20.02b, we have to show a particular need. And there's 2 aspects here. One is involving improper influence by Judge Older, which is reflected in indictment number 1, which was handed down on July 7th. And the second is to determine if the grand jury was misled on the law by the special prosecutors, which would be reflected in indictments number 1 through 5. And the request that we're asking for is the production and inspection of any grand jury transcripts, audio recordings, or as we just learned, PowerPoint presentation by Special Prosecutor Weiss, which would be reflective, presumably, of the law and how it may have been interpreted by the special prosecutors. We have to show, with regards to Judge Older, that there was improper grand jury influence, and the particularized need is the authorization by which we are seeking this. So we have to determine if there was an unauthorized person before the grand jury. And we have the information that's been established just now that Judge Older went into the grand jury approximately 11 o'clock. He may have stayed for about 45 minutes, and then he went back. We don't know what Judge Older was doing before the grand jury, since he wasn't a witness, and he surely wasn't a special prosecutor or a bailiff or a stenographer, those people that would typically appear within the grand jury room. And we know that Judge Older had gone before and entered that grand jury room on at least 2 occasions on July 7th. What we'll be able to link up a little bit later, Judge, is that the indictment of July 7th was actually returned on or before 2:58 p.m. So there's a window of approximately 3 hours that occurred. We don't believe that any fact witness went before the grand jury during this time period. So the entry prohibited is that Judge Older had no business going before the grand jury. Judge Older, being a criminal judge and also having been a prosecutor for a number of years, is well familiar with grand jury secrecy and grand jury procedure. We believe that Judge Older's conduct raises serious questions about for a number of items that we're going to get into, including the disclosure of grand jury material, possibly to his wife, improper ordering, sealing of grand jurors' names, secreting the unfiled indictment that was returned on July 7th, issuing an arrest warrant for Mr. Paxton, knowing that he was about to recuse himself, and of course, as we talked about, improper entry into the grand jury room. So the transcripts are needed to determine and help determine if the grand jurors volunteered to, if you would, they were volunteered to indict Mr. Paxton if they said something before the grand jury. It would reveal possible prejudice by Judge Oldner. We believe that it's a per se violation of the grand jury rule because he was not authorized to do so. We also believe that there may be matters that would be reflective of information that Sissy Oldner may have learned later on that would be within the grand jury transcript, and that the transcripts might show that there was impartiality or independence of the grand jury that was affected by Judge Oldner's presence. Now, we've also, as a second basis, we have the particularized need is the basis of law, if you will, the legal instructions by the special prosecutors. Did they disclose the proper law by which the indictments were handed down and considered? Did it involve the determination, were they misled on the law? We know now, too, that the July 28th indictment was re-indicted on the 18th and July 18th, and also late last night, the special prosecutors have filed an amendment, again, involving the July 28th indictment and also an amendment for the July 7th indictment. So it's cleaning it up. But it's more than cleaning it up, Judge, because it also reflects that they made mistakes. They made serious mistakes in charging and serious mistakes in what the law is in order to charge the individuals. Mr. Paxton.
Let me interrupt you just a minute.
Sir.
You remain seated. Are you saying there have been amendments to the securities investment registration indictment? I was not aware of anything involving that cause number that ends in 1-3.
No, sir, not yet, but that was filed by the special prosecutors late yesterday.
Oh, okay. And that will be addressed in the future. I got you.
Yes, sir.
I got you.
Yes, sir.
I got you.
But
Okay.
they wouldn't be doing it unless there was a problem with the way it was pledged.
Okay.
And so we want to get the transcript and the proceedings that happened in the grand jury to help determine if, in fact, that the grand jury was misled or improperly instructed on the law, because that is a basis by which we can quash an indictment.
Okay, I'm with you. Go ahead.
Okay, so just to take a look at this with a little more particularity and clarity here, on July 7th, that was the very first meeting that this grand jury ever had. The morning session was conducted initially up until from 9 until about 11 o'clock by the Assistant District Attorney Lyko here, who just testified, who gave an overview of the duties and responsibilities of that grand jury. We know that Judge Oldner at about 11 o'clock entered the grand jury room. We know that he may have stayed there maybe as long as 45 minutes. We don't know when he actually left. We don't know if the grand jury actually took lunch, although ABA, Lyko said that it seems like they worked through lunch. But in the afternoon, the grand jury would have had to go through the facts and the law in this particular case. We believe that there were no fact witnesses that testified, and that the presentation was made by Mr. Weiss. Mr. Weiss was apparently the only special prosecutor in the grand jury, but Mr. Weiss, to our knowledge, has never made a grand jury presentation before. He's been a lifelong criminal defense attorney, and we know that he's never prosecuted a securities fraud case before. So we have questions about whether this grand jury actually heard what really the law was, and if the facts fit the law here. And we know that the indictment was returned at least by 2:58 p.m. Not a very lengthy presentation. Moving to July 28th, indictments 2 and 3. July 1st, there was, leading up to this, there was a statement by the special prosecutors in front of Channel 8, which is WSAA, that they would be calling about 8 or 9 witnesses before the grand jury. But we know that there were no fact witnesses that actually appeared before the grand jury on that day. And we know that, in part anyways, we believe that that was because the special prosecutors erred and not ordered a actual stenographer to be present during the presentation, so no witnesses were called. And there were these two indictments were handed down approximately 4 o'clock p.m. And again, both of these special prosecutors have never prosecuted a securities fraud case, and we believe that these indictments are flawed too, because again, on the 18th, they were, quote, cleaned up, and they're attempting to, quote, clean it up again by these filings that were done at the 11th hour yesterday, which is indicated by these filings that the grand jury may not have heard what the proper law was to fit this fact scenario, which gives us justification to get the material and the transcript so we can further enhance these motions to dismiss. The grand jury indictments, what we call 4 and 5, again, it was just to clean them up, and it's reasonable to inquire whether the grand jury were given the correct explanation of the law, and were they misled into believing that probable cause existed. Don't forget, this is a fairly new grand jury, and especially going back to July 7th, this was the very first case that they heard. So the special prosecutors did not file a response to this motion, and in one of their responses they said that our assertions are wholly conclusionary and without support in the record. And so we believe that this just opens the door and that we are allowed to get the grand jury transcript. And so we would ask this court to make those grand jury transcripts available to us in advance of the court's rulings on these motions, if you were going to deny any of our motions, so we can supplement our motions, or at least leave the court to file new motions if those transcripts reveal that there is a problem, as we believe, in the way that these special prosecutors indicted the case. Thank you, Judge.
Yes, sir. Mr. Schaefer? Oh, Mr. Board.
And I'm going to have a really hard time sitting down to address the court, Your Honor.
Do whatever
out of habit.
Do whatever you feel is most comfortable.
Thank you, Your Honor. In their petition to disclose the proceedings, it seems that the defense's request is actually sort of a multifaceted request. I mean, grand jury proceedings, as a general rule, aren't in whole reported. So what I'm interpreting the particular petition to be requesting are recordings, all right, minutes of the grand jury proceedings and any transcriptions of witness testimony. To get any of this material, the defense is going to have to show particularized need. And one of the things that you may have noticed when you watched this PowerPoint, listen to the argument that Mr. Hilder made, is they didn't cite a single case showing that any of what they propose is in fact particularized need, because they can't. There is no case law supporting their position. As prosecutors, we are obligated to maintain the secrecy of what happens inside the grand jury. And as part of that obligation, we can't disclose even recorded testimony of witnesses without court order. And while, for at least as it relates to witness testimony, for the actual 5 witnesses that came in to testify for the securities fraud case, we can't disclose any of that without court order. And to get a court order, what they actually would need to show is that they had particularized need to show that they need to see this testimony. And there have been many, many cases where the defense has tried to raise particular concern about impeaching a witness or showing inconsistencies. And in each of those cases, what you'll find is that the courts have always found that that is not sufficient to show particularized need. That being said, as it relates to witness testimony, which was reported in this instance, if the court should order that, in the spirit of the Michael Morton Act in advance of trial, and to make things proceed more efficiently, we would just simply ask that A, that there's a court order, and B, that the court inspect anything prior to turning it over to the defense as part of that process. As it relates to recordings, a lot of what the defense is asking for is not something that is recorded. It wasn't recorded. They're asking for things that include attorney work product in this case. They want Mr. Weiss's PowerPoint presentation. There's absolutely no legal authority which would allow for the defense to get information like that, pieces of information which were disclosed to the grand jury as part of the attorney's description of what went on. There is no particularized need to show that they can show concerning the actual minutes of who went in. In fact, what you heard and what you saw in the PowerPoint presentation is a great deal of conjecture about what must have happened, about whether or not they could have considered certain law, about whether or not they did hear from witnesses. What we know for a fact is that as it relates to the securities fraud case, there were at least 5 witnesses that went into the grand jury. So their conjecture is wrong. Additionally, they make a circular argument as it relates to particularized need. What they're telling the court is that we want it because we need it, which tells you they can't show particularized need because they're asking for it. It's as simple as that, and that's why there is no case law to support their particular position. There's absolutely no problem, despite what defense has raised concerning the indictments, and it's very clear from the indictments exactly the kind of criminal conduct which is being alleged. The fact that these indictments are being amended, the prosecution is seeking to amend these particular indictments, has nothing to do with showing a particularized need. If amending the indictment helps Mr. Paxton understand or eliminates the claim that he can't understand certain things about what it is his criminal conduct is in this case, then it's not a problem for the prosecution to make such an amendment. It is something that can help make the process more efficient and has absolutely nothing to do with the showing of particularized need in this case. Again, the reason that the PowerPoint presentation and Mr. Hilder's presentation cites not a single case showing that any of the items that they represent might be showing a particularized need is supported by any case law whatsoever is because there is none, Your Honor. There is none whatsoever. We would ask that the court decline the request for minutes and recordings. Many of the instances that they mentioned, there are no recordings in the first place. And then as it relates to the transcripts of any witnesses, that if the court should order those transcripts to be provided, that the court inspect them prior to release.
Mr. Hilder, response.
Yes, Judge. I mean, it was felt that we don't need to show a case law as such, other than what we've already put into our motion, because it's well rooted within the statute. And the statute says that we're entitled to disclosure upon particularized need. We spelled it out to the court, and the prosecution said, well, the matters are clear. It's clear as mud. And that is why, here we are arguing before the court and them having filed an 11th-hour petition to try to clean up the indictments, because that underscores the necessity for us to get these transcripts. And I will concur with counsel in that we believe that she's made a statement that that the materials would have to be turned over pursuant to court order. Well, yes, of course. That's why we're making the motion before the court. There has to be a court order pursuant to the Code of Criminal Procedure. And yes, we would expect that the court review it before they turn it over to us. And we would concur with that too. But we've laid out the particularized need here. And I think we're, to call a PowerPoint that the prosecutor brings to show the grand jury work product is just not true. It's not work product as such. It is something that they have shared with the grand jury. It underscores the need for us to also take a look to see what the law was, what these prosecutors told the grand jury, whether it was true, whether it was accurate, whether it had a basis, whether it gave them the ability to properly analyze probable cause. And that's what that PowerPoint does. So I think that they have to turn that over as well. And so we've already spelled out our argument to the court, and we ask that the court make a ruling and allow us, as I said, to either supplement our motions at a later date or to reurge some of the motions at a later date as well. Thank you.
Yes, ma'am.
Just briefly, if I might cite the court to a particular case that I believe might be of assistance, Garcia versus State, which is 454 Southwest 2nd 400, tells the court...
454 second, what?
Southwest 2nd 400.
400, thank you.
And at page 403, Your Honor, the court says, it has been generally recognized that an accused is not ordinarily entitled to inspection of grand jury minutes or testimony for the purpose of ascertaining evidence in the hands of the prosecution or for the purpose of discovery in general. And that's exactly what defense seeks to do at this time. And we would ask that the court deny the request.
Right. I had previously indicated to counsel that I intend to take all of these matters under advisement and will issue written orders at some time in the future. Is that agreeable with the defense?
Yes, sir.
And that's agreeable with the state?
It is, Your Honor.
All right. We have been going approximately an hour and 15 minutes. Does either side wish to break, or do you want to? It's my understanding now we're just going into legal arguments on the remaining motions.
That is correct.
Do y'all wish to take a break now, or keep going until after Mr. Matea has finished his presentation?
I've been chomping at the bit to get going, Your Honor.
Is that agreeable with the state?
We're fine either way, Your Honor.
Okay. If you can go, let's go.
Let's do it.
All right. Tell me which motions you will be directing my attention to.
Your Honor, what we're going to do is we're going to walk through the various securities-focused writs and the motions to quash.
So these are writs 1 through 4?
There actually is 1, 2, and 4.
1, 2, and 4.
Really focused on the impoundment of grand jury.
Okay.
And then we're going to go through also the motion to quash for failure to give adequate notice as it relates to the failure to register count.
Okay.
And then the motion to quash for failure to give adequate notice on 2 securities fraud counts.
Okay.
Okay.
I'm with you.
May I approach the bench?
Yes, sir.
Your Honor, I have a PowerPoint presentation as well as the one exhibit where we seek to introduce. Copies have been furnished to the defense.
Any objections as far as for purposes of this hearing for me looking at these PowerPoint presentations as well as an exhibit?
Can we have a moment to look through them?
Yes, sir.
It's a PowerPoint presentation, not unlike what Mr. Hilder went through. I just have a copy there for you.
Thank you.
Can we go ahead and take a break to read this? This is about 25, 30 pages we've never seen.
All right.
Well, Your Honor, they didn't have a chance to look at Mr. Hilder's presentation, and we may not look at theirs either in advance, but...
Well, that's a ridiculous one.
Let-
To us right now, yes, this should be ready to go.
Let's take 10 minutes. All right, we'll be in recess. 10 minutes. Thank you.
That